Yes, please. Let's prepare to begin. Yes. No, I'm doing it.
Madam Prima, before we begin, I asked if anybody needed an interpreter. Would you like me to ask again?
Yes, let me introduce you. Okay, just 1 second. And you can even use this mic if you'd like. All righty. Good morning. My name is Felicia Orth, hearing officer appointed by the Water Quality Control Commission to conduct a hearing in the matter of proposed new rule 20.6.8, the New Mexico Administrative Code. This is ground and surface water protection, supplemental requirements for water reuse, docketed by the Commission Administrator, WQCC 23-84R. We have a number of things to do this morning, but before I go into that, I'm going to introduce Lisa O'Grady. She is our interpreter between Spanish and English. Ms. O'Grady, would you please make your announcement from here?
Good morning. If there's anyone present in the hearing room that would like in Spanish interpreter services, please come forward and I will provide you with the equipment. Buenos días. Si hay alguien aquí presente que requiere servicios de interpretación, por favor, pase adelante y les paso los audífonos. For anybody who is online that requires interpreter services, there's a globe at the bottom left hand of your screen. You will need to click on the globe and choose Spanish. If you want to hear the interpretation from Spanish into English, then you will need to click on the globe and choose English. Si hay alguien que está compareciendo desde el internet por Webex, entonces por favor para escoger su canal, al pie de su pantalla, de la pantalla, la mano izquierda, hay un globo. Por favor, seleccione el globo y luego puede seleccionar español. Si quiere escuchar la interpretación de español al inglés, por favor, seleccione el globo y luego puede seleccionar inglés. Thank you. Gracias.
Thank you very much. In addition to having interpretation between English and Spanish, we have a court reporter, Teresa Dubois, with us to make a transcript of the hearing. This is a resumption of a hearing we began on May 13th, continued through May 17th. First, let me say, as to the public comment expected, that we have 2 public comment sessions today. One is at 1 p.m. So we'll take a lunch break at noon, come back for the 1 p.m. public comment period. The second one is at 5 p.m. Every subsequent day this week in which we conduct the hearing, again, there will be public comment opportunities, but those opportunities will be at 9 a.m. and 1 p.m. So let me ask for appearances. Would the department like to start? I know you're not mic'd, but if you stand up and speak loudly, we can hear you. Great, thank you. Ms. Fox? Thank you. Ms. Zanassi? Okay. Do we have Mr. Davis? Thank you. And Ms. Taylor? Okay, thank you. And Mr. Wexler? Thank you very much. Yes. Okay, thank you very much for that reminder. Let's see, do we have Ms. Evans or Mr. Cox? No?
Honor, Colin Cox for the Center for Biological Diversity.
Okay, thank you, Mr. Cox. I can see you online. Let's see, Mr. Maxwell, I think I see you online.
Nicholas Maxwell appearing for the record today.
Thank you very much. And then we have Mr. Mr. Sage, Mr. Atencio. Are any of you on the platform? Okay. And Mr. Hightower. All right. Oh, there you are. Thank you. All right. Thank you all very much. Again, we have a number of things to do today. Now having had the appearances and knowing when the public comment period will begin, we're going to turn to Commissioner McWilliams. In the event, Commissioner McWilliams, you have a statement around the motions for disqualification. We did get several documents, including one this weekend from NMOGA, responding to the motion. All those documents are in the record, but if you'd like to make a statement, this would be your opportunity.
Yes, thank you very much. I'd like the opportunity to address these baseless allegations and clarify a few issues. Upon my appointment to the WQCC, I filed an initial financial disclosure. My financial situation has not changed since my initial filing, and no further disclosures have been required. My husband and I are part owners of an oil and gas company in the San Juan Basin. We use recycled produced water exclusively within our oil and gas operations and have no need to use produced water outside the industry. Therefore, there will be no financial benefit from these rules. I have not worked for ConocoPhillips in more than 8 years and have never been a part of the New Mexico Produced Water Consortium. Neither myself or my husband, nor Logos Energy or any subsidiary is a member of NMOGA and hasn't been since 2021. I am a member of IPANM board, but was not on the executive committee when hiring of Montgomery and Andrews and Mr. Wexler for any legal services to IPNM was secured, and have had no involvement in obtaining legal services for IPANM. Additionally, IPNM is not a party to the hearing, and I've had no ex parte communications regarding this hearing. Montgomery and Andrews does not represent Logos and hasn't for several years. 6 years ago, I filmed an educational video which aimed to inform the public about fracking. I did this on a voluntary basis and was not aware that the video continues to be used. This video has no relationship to the proposed rules, or this hearing. Finally, Logos is not a permit holder or an applicant for a permit under the Water Quality Act, which is governed by this commission. I believe that my background as an engineer in the oil and gas industry is one of the reasons I was appointed to the WQCC. My expertise allows me to offer valuable insights on rules affecting the oil and gas industry, helping to ensure that the commission makes informed decisions. Despite my industry background, I remain committed to the Water Quality Act's objectives of protecting public health and enhancing water quality. My obligation is to serve the public interest, not personal or corporate gain. As such, there is no reason for me to recuse myself from the hearing. If the commission would allow, I intend to remain a participant in the hearing and remain committed to serve New Mexico. However, I do not want to stand in the way of due process. In order to allow science to have its day in court, I will abstain from the final vote while providing my fellow commissioners my perspective for this for their consideration. Thank you.
All right, thank you, Commissioner McWilliams. I understand there might be some feeling that as a non-dispositive motion, it might be a motion I could or would rule on. I'm deferring that ruling to the commission as a whole. I understand the commission has counsel from the New Mexico Attorney General's office. I also understand that there may be another forum in which this question is explored. I don't think, however, that anything I might say on the basis of these pleadings would be particularly helpful. So the commission can take this up at a properly noticed meeting sometime before they deliberate. But that's all we're going to do on that motion this morning. Thank you. Let's see. Ms. Fox, you asked about your motion to exclude some of NMOGA's witnesses, exhibits.
Madam Hearing Officer, we have a new commissioner. Could we introduce
Yes, thank you.
Mr. Bailey?
Commissioner Bayless, if you would please introduce yourself.
I'm here on behalf of Toby Velasquez, New Mexico Parks Director. I work for him.
Hold that closer to you.
I'll quickly on my background. I have 2 engineering degrees. My master's thesis had to do with nutrient kinetics in a receiving stream. Worked 16 years for the Alaska Department of Environmental Conservation. I was the chief of water quality for the state. I also worked on the Exxon Valdez cleanup. I've had 5 years with OCD early in the 2000s and in the teens. I also took some time off to work overseas. I worked in construction operations and design of LNG plants. I've lived in Peru, London, Perth, Tokyo, and Houston. So there were highs and lows. I've been working for state parks now for 3 years. I do the design and help with the operations of the water and sewage treatment plants at our 35 parks. And I'm an operator.
Thank you very much, Commissioner Bayless. Let's see, Ms. Fox. I had been agreeable to taking up this motion when you asked in the email last week. I'm wondering, though, if it would be better taken up when NMOGA actually offers its exhibits and perhaps offers them without foundation, for example. And we could take it up then. Come to a microphone.
Madam Hearing Officer, whatever your pleasure. On the one hand, I'm prepared to argue it today, and I do think it's right today, but whatever your pleasure.
I think I'd prefer to do it later, notwithstanding my email response there. All right.
Thank you.
All righty. So I believe at this point, though, we turn to your witness. Yes, Ms. Fox? All right. Under the commission rules, all testimony is taken under oath and is subject to cross-examination. So Mr. DeSalen, if you would please come to the witness table. That's all right. Okay.
Where's Pam? There you are. I'm going to need to screen share in just a bit.
Yes, I believe Ms. Jones will help you with.
Onto the WebEx. Should we take a few minutes while I do that?
All right. Yes.
Madam Hearing Officer,
Commissioner Brankard.
I think we discussed this at the end of the last meeting. Is there an order for the testimony?
Yes, sir. We do always make allowances for witnesses with time constraints, but we have been generally going through the petitioner and then those generally supportive of the petitioner, and then move along the spectrum to those not as supportive of the petition. So we hear from Ms. Fox and Mr. DeSalen now. Then we move to new energy economy. Then there are some parties who are here supportively without witnesses. And as we move along, we move toward Mr. Maxwell and Namoga. We'll presumably finish up with Namoga. And there's always a possibility of rebuttal and surrebuttal and all of that, but folks, parties have been including that in their testimony.
Have we heard from Wild Earth Guardian?
Yes.
They testify.
Hold on. Mr. Davis? Okay. Commissioner Brankard wanted to know if we'd heard from a witness for you. You have to come to a microphone.
Hello,
Yes.
it's on now. Pardon me, Tim Davis, Wild Earth Guardians. Guardians does have one witness in this matter, Melissa Troutman. I sent around an email last night to the parties seeking their positions on potentially stipulating that Miss Troutman's testimony be entered into the record for the reason that she is recovering from an unexpected surgery. I do not know when she may be available to testify. There was one objection as of last night to doing so, and I believe that her availability will be a moving target. And so I really have no further information that I can give the commission at this time. I'm hoping that we can all reach some sort of a resolution on when we could potentially make her available in the future. and would request that that is done remotely. I don't want to bring everyone back into the hearing room in person if it's not necessary.
Thank you, Mr. Davis. Other questions, Commissioner Brankert?
Actually, yes. In your procedural orders, have you placed any limitations on the parties filing additional amendments to the rule proposal?
Yes, I believe there was a deadline for that. I believe it was the same deadline as filing an NOI. If you have an amendment to the rule you wanted to file, I thought that needed to be explained in the NOI. Is that not true?
Madam Hearing Officer, Commissioner Brankard, we could file amended proposed rules with the rebuttal NOI on the one hand, but on the other hand, the practice has been that you can file additional proposed rules throughout the hearing process, depending upon the evidence.
In fact, we had that discussion at a pre-hearing conference. As the evidence comes in, sometimes the parties move, thankfully, toward one another on what they are willing to accept in a final rule.
Madam Harris, I realize I'm slow, but it's sort of difficult to keep up with what everybody's current positions are because they keep filing more amendments to their positions. I would assume that when we're done with the testimony, the parties will be allowed to file a final proposed amendments.
Yes, the parties understand that they're being asked to put closing arguments in writing, not to offer them verbally at the end of the hearing, and to also offer whatever final version of the rule they believe the commission should adopt.
I guess I just hope the parties will sort of stop filing amendments and wait till they get to do that after the testimony is over. It's a bit of a moving target here with all the parties and all the different proposals.
I think they're just trying to be forthcoming, Commissioner Brankert. But all right,
Thank you.
thank you. Ms. Fox, are you on the WebEx?
Thank you, Madam Hearing Officer, Commissioners.
Hold on one, I'm sorry.
Oh.
I just wanted to confirm you were on
Oh.
the WebEx and now I can see it
Yes.
on the screen. So first I have to swear in the interpreters. Ms. O'Grady and your team member whose name is?
I, Lisa O'Grady, am handling the technical aspect. My interpreters online are Amelia Cardena and Betty Zeman. Ladies, if you can please go on the English channel to take the oath.
Okay, thank you. Do you and each of you swear or affirm that you will interpret faithfully between English and Spanish and English for this record? Thank you.
Betty?
Thank you very much. And now, Mr. DeSalen, do you swear or affirm that you will tell the truth? Thank you very much. And I'll ask you to spell your first and last name for the transcript. Thank you. Go ahead, Ms. Fox.
Thank you, Madam Hearing Officer. Mr. DeSalen, what is your current employment?
Yes, I'm an environmental lawyer, and I currently work for Coalition for Clean Affordable Energy. But I want to emphasize that today I am not testifying on behalf of Coalition for Clean Affordable Energy. I'm testifying only on behalf of Amigos Bravos and the Sierra Club.
What is your educational background?
I have a Bachelor of Arts degree in political science from Boston University College of Liberal Arts, and I have a Juris Doctor from Boston University School of Law, and an LLM, which is a Master of Law from Katholieke University in Leuven, Belgium.
Would you briefly describe your work background?
Yes, I've been practicing environmental law for approximately 40 years. After law school, I worked for the Massachusetts Executive Office of Environmental Affairs in Boston. Next, I worked for the U.S. Environmental Protection Agency in the Office of Enforcement and the U.S. Department of Justice Environmental Enforcement Section in Washington, D.C. In 1993, I moved to New Mexico and worked for a series of state government jobs over a period of about 25 years. I worked first in the Office of the Attorney General in the Environment Division. I then worked for the Environment Department for about 14 years in the Office of General Counsel. And finally, I worked at the Interstate Stream Commission. Since leaving state government, I've worked now for two nonprofit organizations. The first one was the New Mexico Environmental Law Center, and the second one, as I mentioned, the Coalition for Clean Affordable Energy.
Has your work included drafting laws and regulations?
Yes, it has. I've worked on drafting regulations and statutes, legislation throughout my legal career, and I can quickly mention a few of them. So while I was at the Environmental Protection Agency, I helped to draft portions of the Federal Hazardous Waste Regulation. While at the Attorney General's office, I drafted amendments to the Federal Superfund Law. And then while I was at the Environment Department, I drafted regulations on state certification of federal permits, which this commission adopted. While working for nonprofits, I've worked on several regulatory rulemakings, the adoption of the methane waste rules before the Oil Conservation Commission, then the 2021 triennial review of surface water standards, which was before this commission, and then most recently, the Advanced Clean Cars 1, Advanced Clean Cars 2, Advanced Clean Trucks, and nitrogen oxides omnibus rules. And all of those were before the Environmental Improvement Board, as well as the Albuquerque-Bernalillo County Air Quality Control Board. I've also drafted at least half a dozen bills that have been introduced in the New Mexico legislature. I've testified before congressional committees on several occasions. I've testified before the New Mexico legislature, the New Mexico Mining Commission, and the New Mexico Oil Conservation Commission.
There was a suggestion during the Environment Department's testimony that the proponent of deleting unused definitions from the rule had never implemented a regulatory program. How do you respond?
Yes, I heard that testimony, and I sort of assumed that it was directed at me, and I have to disagree with those statements. I have implemented and enforced regulatory programs throughout my legal career over a period of over 40 years. So I can give you a few examples. While I was at EPA, I implemented and enforced the Federal Hazardous Waste Regulatory Program under the Resource Conservation and Recovery Act. I implemented and enforced the federal permitting program under the Clean Water Act and the federal drinking water program under the Safe Drinking Water Act. While at the New Mexico Attorney General's office, I helped establish and I represented the Natural Resource Damage Program in New Mexico. And that program is governed by regulations promulgated by the United States Department of the Interior and the National Oceanic and Atmospheric Administration, which is part of the Department of Commerce. And when I was at the Environment Department, I helped to implement and enforce the State Hazardous Waste Program under the Hazardous Waste Act, the Groundwater Protection Program under the Water Quality Act, and the State Air Program under the New Mexico Air Quality Control Act. And these are all permitting programs. So I am very familiar with the implementation and enforcement of environmental permitting programs.
Is ABSC Exhibit 5 an accurate copy of your resume?
Yes, ABSC Exhibit 5 is my resume, and it is accurate and up to date.
Can you please outline the direct testimony you will give today?
Yes, and I want to begin by thanking the commission for allowing me the opportunity to appear before you and testify today. And I also want to thank the commission for your efforts in reviewing this rule and the rather voluminous record that supports it. So I'm going to discuss the department's proposed rule from a legal drafting point of view. And I have several recommendations to make this rule clear, to make it more precise, and to make it more concise. And each of my recommendations is designed to make the rule better, to improve it, to make it more enforceable, and to make it more understandable. So I will briefly summarize my testimony. First, I will explain why some 23 definitions not used in the body of the proposed rule should be deleted. And these unused definitions are highlighted in yellow in, excuse me, in Amigos Bravos and the Sierra Club's red line of the rule, which is ABSC Exhibit 1. And I do not find the department's rationale for retaining these definitions to be persuasive. Second, I will respond to the New Mexico Oil and Gas Association's testimony on the reuse of wastewater for potable purposes. The department's proposed prohibition on potable application of produce water, as well as industrial wastewater and domestic wastewater, needs to be retained. Now, in the department's proposal, the prohibition is under Section 200, which applies to domestic wastewater. You can see on the heading of Section 200, it refers to domestic wastewater. Now, I recommend that this provision or this prohibition be moved to Section 100, which is the general prohibition. And again, as the department has written the prohibition, it applies to all three types of wastewater that are regulated under the proposed rule: domestic wastewater, industrial wastewater, and produce water. So the proposal, our proposal, would place the rule in a more appropriate location in general provisions of the rule. Third, I will discuss the deletion of unnecessary wording in the department's prohibition against discharge of treated produce water, and that's in Section 400A4. Fourth, I will discuss three proposals that Amigos Bravos and the Sierra Club are making to strengthen the notice of intent procedure for demonstration and industrial projects. And that's under Section 400B of the proposed rule. The department has either adopted our three proposals, or at least has not objected to them. And finally, I will discuss Amigos Bravos and Sierra Club's objection to including industrial projects as an authorized use in the proposed rule. I'm not going to cover everything that's in my written testimony, only the most important points. And I also want to note that the Environment Department has accepted a few of our proposals, and we very much appreciate that.
Can you please identify ABSC Exhibit 6?
Yes. ABSC Exhibit 6 is my direct testimony, which was filed on April 15th, 2024.
Do you adopt it as your sworn testimony today?
Yes, I do.
Can you identify ABSC Exhibit 7?
Yes.
Exhibit 10?
Yes, ABSC Exhibit 10 is my rebuttal testimony, which was filed on May 6th, 2024.
Do you adopt it as your sworn testimony today?
Yes, I do.
Mr. DeSalen, I'm going to ask you a few questions about the sources you reviewed or consulted in preparing your testimony. First of all, are there any New Mexico rules that govern the drafting of state rules?
Yes, there are. The State Records Center has adopted rules governing the format and style of state rules. Essentially, these are rules on drafting rules. And these rules apply to this commission, and they're codified at section 1.24.10, New Mexico Administrative Code, or NMAC. The rules provide that style, quote, shall be guided by the Legislative Counsel Services publication entitled Legislative Drafting Manual. And the relevant portions of the latest edition of the Legislative Drafting Manual is ABSC Exhibit 7. And I want to say that I disagree with the statements of Ms. Fulham and Mr. Herman that the legislative drafting manual applies only to drafting legislation. And that was in their rebuttal testimony. These rules expressly provide that the manual shall be used in drafting state rule. And that's at section 1.24.10.12A NMEC.
In addition to your own knowledge and expertise, did you consult any reference materials to prepare your testimony?
Yes, I consulted a number of references, drafting rules and legislation. My references are listed at the end of my direct testimony, my written direct testimony. And the guidance documents and references that I consulted comport with my own understanding of good rule and legislation drafting.
What documents did you review from this proceeding?
Yes, I read the notices of intent to file technical testimony and the rebuttal notices of intent from all of the parties. I read the direct and rebuttal testimony of all the parties. I read the department's proposed rule, the department's revisions to the proposed rule, and the revisions of the other parties. And I read many of the exhibits, although I did not read all of the exhibits that have been submitted. I also reviewed the public notice and the pre-hearing order.
What is the basis of your recommendation not to include unnecessary definitions in the proposed rule?
Good legal drafting should be clear and concise. It should not contain unnecessary words. A legal document certainly should not contain definitions of terms that are not used in that document. I think this should be obvious. And there are good reasons for this. It's not just because we've always done it this way. First of all, defining unused terms is simply unnecessary. It needlessly makes the rule longer and more complex. But if anything, we should be trying to make New Mexico's rules shorter and simpler. Second, definitions of unused terms lacks meaningful context. So having unused definitions makes it very difficult to follow the proposed rule, to grasp what the defined terms mean, and why they're even there in the first place. And it's very difficult to assess and analyze a proposed rule, or excuse me, a proposed definition to make sure that it's accurate and applicable and complete when you don't have any regulatory context for the definition. And this principle is especially true for technical terms, such as many of the definitions in this proposed rule. Without any regulatory context, this commission cannot consider the definition on an informed basis. Third, drafting unused terms makes the proposal very confusing. um, a, a reader might see a defined term that seems to be very important. So I can imagine, for example, a farmer that sees the term irrigation application. Then the farmer goes and looks at the rule to see how the term is actually used in the rule, but can't find it. So that farmer is likely to come away very puzzled and unclear as to how the rule is supposed to work. Fourth, defining unused terms suggests that the rule was carelessly drafted. Many readers will conclude that the unused definitions are a relic from earlier drafts of the proposed rule. They'll think that someone just simply forgot to delete the definitions as the rule evolved to the proposal. And this confusion is made worse in this proposed rule by the large number of definitions of unused terms. The proposed rule is relatively short. It covers only 6 pages, but it includes 52 defined terms. And of those 52 defined terms, 11 are not used in the proposed rule at all. And another 12 of the 52 defined terms are used only in other definitions. And that creates a needlessly complex and convoluted structure. The reader should not need to consult several different definitions to ascertain the meaning of one term. Now, several of these definitions are particularly confusing. For example, the proposed rule needlessly includes definitions of agricultural application, irrigation application, food crop application. The use of these definitions in the rule suggests that produce waters or other wastewaters can be land applied for agriculture or irrigation or for crop uses, food crop uses. But that's not the case. The rule actually says nothing about these possible applications of wastewater. And I want to point out that Ms. Tiffany Rivera of the New Mexico Farm and Livestock Bureau made very much these same points in her public comments. She recommended that the terms agricultural application, flood irrigation application, food crop application, and livestock application be omitted from the proposed rule, just as we have recommended. And I can give you a reference for that. That's in the volume 3 of the hearing transcripts at page 17. And then I have one final point that I want to make here. Ms. Fulham questioned my numbers in her rebuttal testimony. So as a rebuttal exhibit, I have prepared with some assistance a chart that lists each of the department's proposed definitions that are either not used in the proposed rule or used only in other definitions.
Madam Hearing Officer, may I approach to hand out exhibits?
Yes.
Mr. DeSalen, is that chart marked ABSC Exhibit 12?
Yes, it is.
Are you persuaded, that chart also, by the way, is in the Dropbox that is being used for this hearing? Are you persuaded by the Environment Department's rationale for defining these unused terms?
No, I'm not. The department's original rationale, as I understand it, was that the department would actually use these terms in future rulemaking. But that's not a satisfactory reason for including these definitions in today's proposed rulemaking. Although the Environment Department may intend to define these terms now for the future, that future may change. The future rules may be adopted in a form that is very different from what the Environment Department now anticipates. So the obvious answer here is simply to adopt the definitions as part of that future rulemaking. At that time, the terms will actually be used, and the context for these terms will be clear, and an informed analysis of the content will be possible. Now, in their written and direct rebuttal testimony, and in their oral testimony that was given in May, the department witnesses stated that the definitions will allow discharge permits to be referenced in a consistent manner. And they testified that the definitions will allow consistent oversight. But that rationale is equally unpersuasive. The department's testimony does not explain what problems these definitions will solve. There isn't any evidence that any of these terms are even in any existing discharge permits. And there's no evidence that any of these terms have been applied inconsistently in the past or have created any confusion. But there's another sort of more fundamental problem with the department's rationale. If this rule is adopted as the Environment Department has proposed, the scope of the definitions will not extend beyond the rule itself. So the proposed rule will not serve to define or redefine terms in existing discharge permits. Those permits are read within their four corners. So the definition would not have, or to me, these definitions, these unused definitions, would not have the effect that the department seems to intend. Now, if the department needs to define these terms for purposes of implementation and enforcement of its groundwater discharge permits, it needs to put the definitions in the permit. And all discharge permits contain a section right up front with all the definitions. Alternatively, the department could issue a guidance explaining how it intends to interpret and enforce the terms of the permit. But the department's justification for putting these unused definitions in the rule does not hold up to scrutiny.
Has the commission ever confronted a similar situation where the department has proposed definitions for terms not used in rule?
The commission confronted a very similar issue in the 2021 triennial review of surface water standards. The department had proposed definitions for two terms that were not used in the surface water rules. And Amigos Bravos, which was a party in that proceeding, objected to those two definitions. Amigos Bravos pointed out that these two terms were not used anywhere in the regulations and that they served no regulatory purpose. During deliberations, this commission agreed, and it voted unanimously against including these two definitions in the rule. And a copy of the relevant pages of the transcript from that commission proceeding or commission's deliberations is ABSC Exhibit 8. And in this case here, the unused definitions likewise should be deleted.
Mr. DeSalen, you recommend a new section 101 in the proposed rule. Could you explain why?
Yes. The proposed rule includes a prohibition on the department issuing a permit for potable application of reuse water. And that's in section 201 of the department's proposal. The definition of reuse water includes domestic wastewater, industrial wastewater, and produce water. So the prohibition applies to all three types of wastewater as covered on the proposed rule. But section 201, where this prohibition is currently written, is a provision that addresses only domestic wastewater, not produce water or industrial wastewater. So the prohibition is really rather misplaced. Accordingly, we recommend that the prohibition be placed in a new section 101, and that puts the prohibition more appropriately in a section of the rule that applies generally and covers all three types of wastewater. And this proposed change does not make any changes to the substance of the department's proposed rule. All it does is change the placement of this prohibition to a more appropriate section of the proposed rule.
Mr. DeSalen, it's section 400A4, which is the prohibition against discharge of treated produced water to groundwater. You recommend deleting certain language. Can you discuss your recommendation?
Yes. So I recommend deleting a passage from the last portion of section 400.A4 as unnecessary. So I would delete the words, and I'll quote, "without development and adoption of standards specific to treated produce water." And there's a parenthetical, subsection D of 20.6.8.400 and MEC, close paren, and then it goes on. Demonstration projects or industrial projects submitted to the department through the notice of intent process in subsection C of 20.6.8.400 NMEC are authorized to operate following the determination of no discharge permit required issued by the department. And that ends the quote. So all of that quoted wording there would come out. And the reason is that as proposed, section 400A4 would generally prohibit the department from issuing a groundwater discharge permit for treated produce water. But then the last phrase of this, the second sentence here, the first part that I read, would allow the department to issue a permit upon, quote, "the development and adoption of standards specific to treated produce water." This provision is problematic for a couple of reasons. Most importantly, it's totally speculative. It is possible that the department might at some point develop standards governing treated produce water, but no such standards have been developed or proposed or adopted at this point. So it really doesn't make sense to include that provision in there. This provision also references standards that don't exist. The provision consequently is likely to create confusion. And then, as I said, the provision is unnecessary. It's surplusage. It adds to the length and the complexity of the proposed rule, but it serves no regulatory purpose. And then the last sentence in the provision simply reaffirms that demonstration projects and industrial projects approved through the notice of intent process are authorized. That sentence is really redundant and unnecessary. Section 400B and section 400C are clear, they're specific, and they're detailed as to the requirements that demonstration and industrial projects must meet. I therefore recommend that the last part of section 400.A4 should be deleted.
Mr. DeSalen, can you please discuss the three proposals, the proposed amendments put forth by Amigos Bravos and Sierra Club?
Yes, there are three proposals that would amend the notice of intent provisions of the proposed rule, and that's in section 400. First, Amigos Bravos and Sierra Club recommend that the notice of intent for demonstration and industrial projects include information on the concentration of contaminants and on the quantity of the proposed, excuse me, on the quantity of the produced water that would be used. And this information is already required for notices of intent under the Commission's groundwater rules. And that's at section 20.6.2.2101 NMEC. Now, for consistency and for other reasons, we believe this information should be included in the produce water notice of intent application. And as Ms. Fulham testified, this information can be estimated prior to operations commencing. And the department has agreed to our proposal and adopted it in its rebuttal testimony. And that's that can be seen in NMED Exhibit 175 at proposed section 400.C1A. And we appreciate the Environment Department's making that addition. Second, we proposed a requirement that the department publish all applications for produce water notices of intent and related documents on its website. That is, and that's covered in my rebuttal testimony. The public has a keen interest in this, in the use of produce water, as evidenced by the extensive public participation in this rulemaking. Making this information available on the department's website is important to help keep the public informed. The department currently publishes applications for notice of intent for pilot projects for produce water on its produce water webpage. The department witnesses have testified that the department intends to continue this practice, and they have no objection to this proposal. The third thing that Amigos Bravos and the Sierra Club propose is results from the cross-examination of department's witnesses, in which they stated that an application for a notice of intent for a pilot program is currently required to give notice of the pilot project to adjacent landowners. So that requirement is reflected in two documents that are part of the record. The first document is attachment B to the 2022 Memorandum of Understanding before the New Mexico Environment Department and then New Mexico State University. And that MOU, including attachment B, is NMED Exhibit 55. Now, attachment B to the MOU requires consortium projects to provide a list of all landowners adjacent to the location of the proposed project. And it also requires a confirmation that the adjacent landowners have been notified of the proposed project. The second document is a consortium guidance document entitled, it's got a somewhat long title here, Guidance on Produce Treatment, Research, Development, and Demonstration, Testing, and Evaluation. And that's dated May 2022, and it's posted on the department's produce water webpage.
I'm showing you what's been marked ABSC Exhibit 13, which has been passed out to the commissioners and is on the Dropbox folder for this hearing. What is this?
This exhibit is excerpts from the guidance document that I just referenced. And on page 25 of the guidance, it provides that nearby landowners should be notified of a pilot project.
What did department witnesses say about adding a requirement in the proposed rule to notify adjacent landowners about demonstration in industrial projects?
The department's witnesses testified during cross-examination that they had no objection to this notification proposal. It is important for neighboring landowners to receive notice of these projects, so they have a better idea of what they're all about and what the potential health or environmental effects might be. So we propose that that the rule require an applicant submitting a notice of intent to notify the adjacent landowners of the project and to do so at the time that the application is submitted to the Environment Department.
I'm showing you what is marked ABSC Second Revised Exhibit 1, which is a red line strikeout of Amigos Bravos and Sierra Club's proposed amendments to NMED's proposed 20.6.8 NMAC, and Second Revised Exhibit 2, which is a clean version. These revised exhibits were placed in the Dropbox folder. Is Amigos Bravos and Sierra Club's proposal regarding notification to adjacent landowners reflected in these two exhibits?
Yes, it is. It can be found at section 400.C1A10. And that 10 is a lowercase Roman numeral, so it's a small x. In there, we propose a provision to require notice to adjacent landowners.
Finally, Mr. DeSalen, what is the basis of your recommendation to remove industrial projects as an authorized use in the proposed rule at section 400.B and C?
The department's proposed rule would include industrial projects as an authorized use. In its direct testimony and exhibits, the department provided no evidence to support this proposal. Given the lack of evidence in my rebuttal testimony, I recommended that this provision be deleted. Now, in its rebuttal testimony and at the hearing, the department witnesses have submitted some testimony in support of this provision. But that testimony is really weak. I understand that industrial projects are prohibited from discharging to groundwater or surface waters under the proposed rule, but industrial projects would nevertheless pose a substantial risk to groundwater and surface water. And this risk derives from the accidents, the spills, and other releases of contaminants that would inevitably occur. And the department has not conducted any kind of quantitative risk assessment or any kind of analysis of those increased risks. And it has not analyzed the risk of a catastrophic accident. So because the risk of harm to groundwater and surface water from industrial projects is substantial, and because the department's evidence supporting industrial projects as part of this rule is quite insubstantial, I recommend removal of industrial projects as an authorized use.
Thank you for your summary, Mr. DeSalen. Sierra Club and Amigos Bravos move for admission of ABSC exhibits, second revised exhibit 1, second revised exhibit 2, and exhibits 5, 6, 7, 8, 10, 12, and 13.
Okay, thank you, Ms. Fox. Do I hear objections to the admission of those exhibits? Mr. Knight?
Madam Hearing Officer.
We need you in front of a microphone. There it is. There's a handheld in front of you.
Thank you. The department would object to the admission of Exhibit 13. It is misleading, and we have not had an opportunity to rebut it in our testimony.
Ms. Fox?
It's offered as proper serve rebuttal, Madam Hearing Officer. It was placed in the Dropbox last Wednesday. Glad to, just trying to limit the number of pages for the commission in this record. Glad to move to admit the entire document. I don't see, and Mr. Knight hasn't explained how it's misleading
Okay.
at all.
I'm sorry.
Mr. Knight,
I apologize. Exhibit 12 is what I was referring to.
the one with the
Sorry.
table of definitions.
Yes.
Okay, what's misleading about it?
There are the excerpts are, just that. They're excerpts. It's incomplete. It does not provide proper context. And again, the real basis is that we haven't had the opportunity to address this in our testimony.
I'm sorry, I think you do mean Exhibit 13. It's this one, right? It's excerpts from the guidance on produced water treatment, research, development, and demonstration, testing, and evaluation.
And again, I apologize for the confusion. It is Exhibit 12 that we're objecting to, not 13. Yeah, it's the table that we're objecting to.
So it's defined terms in 20.6.8, proposed for deletion.
Madam Hearing Officer?
Hold on, I want to.
Yeah, and again, the basis of our objection is that it is misleading and lacks context, and we have not had the opportunity to respond to it in our testimony.
Okay, so my impression though was that it was based pretty closely, tracked pretty closely the testimony from Mr. DeSalen that was filed in April.
Yes, but I would ask that his testimony that was filed timely, that be what is considered by the commission rather than this exhibit. If they're the same thing, then they can just consider his testimony. I don't consider this this exhibit to add anything to that, and it I think it causes more confusion.
Great, thank you. Ms. Fox?
Madam Hearing Officer, this is offered in rebuttal to Ms. Fulham's testimony about the numbers of definitions that we're moving or recommending be deleted. It is proper rebuttal. There is nothing confusing about the exhibit, even if that were a proper objection. And if it is confusing, he has the opportunity for cross-examination right now of Mr. DeSalen on the exhibit, which was dropped in the Dropbox last Wednesday.
All right, thank you. So the objection is overruled. Exhibit 12 is admitted. Were there any other objections to the exhibits Ms. Fox enumerated for omission?
Your Honor, this is Mr. Maxwell. I do have an objection as well.
All righty. Go ahead.
My objection in part concurs with Counsel Knight's reasoning, and so I won't re-elaborate that as well. My understanding is the Dropbox was for large files and demonstrative exhibits. I did not receive any kind of service directly in my email of these exhibits. It's been 2 months since we recessed, and it's my belief that putting these as recently as they've been put on has now brought some shock value to this rulemaking, and for that reason I object. Thank you.
All right, thank you, Mr. Maxwell. Your objection is noted. Perhaps we can take a moment, not now, but before lunch or after the public comment period, to identify anything else that might have been uploaded in the Dropbox folder. I would encourage all parties to look there. I was looking there this past week, certainly. Any other objections to be noted in connection with the proffered Amigos Bravos Sierra Club exhibits? No. All right, the exhibit 2 enumerated are admitted. Thank you, Ms. Fox.
Thank you, Madam Hearing Officer. May I just make one point, please?
Yes.
That is, there is no requirement for us to give notice of exhibits that we're going to offer for cross-examination or SIR rebuttal. There's never been that requirement in any of these proceedings. There is not that requirement in this proceeding. We did not have to put in the Dropbox those 2 exhibits last Wednesday, but we did.
Thank you very much. All right. I think before we launch into your questioning, Mr. DeSalen, that a break would be a good idea. And then we'll come back for the questions by commissioners and the other parties. It's 10:15. Let's break to 10:30. Let's come back from the break, please. Let's come back from the break, please. All right, when we took the break, Mr. DeSalen had completed his direct testimony. We'll turn to commission questions and then to party questions. Commissioner Vihil, do you have questions of Mr. DeSalen?
Not at this time.
Okay, thank you. Commissioner Brankard?
Got so excited there. So, Mr. DeSalen, you were talking about these various definitions, particularly the application definitions that don't seem to have any purpose in there. My understanding in the Environment Department's testimony is that these terms could be used in discharge permits. Is it your position that they don't need to be in the rule to do that? They could just do that in a policy document, a guidance document?
My position is, first of all, that any terms that defined for purposes of a permit need to be in a permit. Putting definitions in a rule that's issued or adopted after that permit has been issued are not going to have any effect on the permit. And my sort of secondary suggestion is that one way for the department to address this issue, if there is an issue, is by issuing some form of guidance document that explains how the department intends to implement and enforce the permits.
Thank you. Just to clarify your first point, isn't it true that the maximum term of a discharge permit is 5 years?
Yes, that is true.
And so after 5 years, each of those permits can come up for renewal and can be modified?
Yes, that's true, and I think I mentioned that in my written testimony.
So 5 years from now, all 95 of those existing discharge permits that have reuse water have been gone through renewal and could have these terms used in them?
Yes, and I presume that they've been issued over a staggered period, so they won't all come up for renewal on the same day.
Okay, so just quickly, you were opposed to NMOGA's proposal to eliminate bench scale projects, which by definition, I believe, is a project that occurs in a laboratory.
I think my opposition was removing it from the definition of a demonstration project. And the key point there, Commissioner Brankard, members of the commission, is that we want a bench scale project to be considered a demonstration project so that it is covered by the notice of intent procedures that are in the rule. We don't want to allow sort of an exemption for bench scale projects.
Right. So it was with those procedures, just sort of curious, your party is proposing to add to the notice of intent procedures, notice to surrounding landowners. Is that correct?
That is correct.
So how would, one of Dr. Thompson's peers at UNM conducting a project at UNM give notice?
Well, I think that if we're talking about a bench scale project, the adjacent landowners requirement probably would not apply.
Okay, so you need to modify your proposal then to drop bend scale projects from that.
Yes, yes, I would agree with that, Commissioner Brankard.
Okay, thank you. That's it.
Thank you, Commissioner Bayless. Okay, Mr. Chair.
I don't really have a question, and I don't know if it's my point or not, but your definition, Exhibit 12, your definition of national pollutant elimination system should be national pollutant discharge elimination system. You left out discharge.
I cannot believe that I did that, Commissioner Thompson, but my mistake, I apologize.
Commissioner Dominguez.
Thank you, Madam Hearing Officer. Good morning, Mr. DeSalan. Thank you for your testimony today.
Good morning, Commissioner Dominguez.
I'm going to work through a few clarifications of some of your testimony and then lean a little bit on your years of rulemaking experience, and hopefully I can get through those questions without Council Fox objecting. So we'll give it a shot here. So a follow-up question from Commissioner Brankard regarding definitions not used in the rule, but they're used in permits. So along with permits, there's a number of documents that are outcroppings of the Water Quality Act or a rule, whether that be guidance documents or groundwater management plans, so forth like that. It seems a little bit monumental to try to define every term used in those permits or guidance documents, trying to define those in a rule, because we're in a continual hamster wheel of those documents changing. It would seem like it would cause the commission to have to look into a crystal ball of knowing what terms might be used in a permit to even try to cover the gamut of that. So I'm trying to wrap my head around that.
I don't think so. I think it's
your understanding from your
bad
testimony
audio.
is, I think,
Sounds like him though. You're right.
is that you're falling back on for the most part, the legislative drafting manual that specifically states do not define terms that are not used in the bill, but here it's in the rule.
Yeah.
So it's your testimony that only the terms that are actually used in the rule should be defined in the rule, including not defining terms that are used in another definition. Is that your testimony?
Commissioner Dominguez, Mr. Chairman, members of the commission, yes, that I think describes my testimony quite well.
Okay, you referred to the legislative drafting manual, and you've specifically referred to 1.24.10.12a, and you specifically read language there, and there seems to be a little bit of a different interpretation from your testimony and Environment's Department's testimony. The question I have for you is, if the State Rules Act or the Commission's rule on rulemaking or the State Records Center, their rule is silent towards a particular issue, should the Commission look to the legislative drafting manual as a guidance document?
Commissioner Dominguez, Mr. Chairman, members of the commission, yes, I think it is a guidance. I mean, I don't think that the drafting manual would be binding on the commission, because I think it says it shall be guided by. So the word guide is in there, but it certainly seems to me that the commission in adopting rules should follow the drafting manual to the extent that it can, unless there's a very good reason to deviate from it. And in this proceeding, the testimony from the Environment Department does not indicate to me that there is any good reason for in any way deviating from the Legislative Council Services drafting manual.
Okay, thank you, Mr. DeSalin. In your written testimony, you've Amigos Bravos has proposed a minor change to the definition of produced water, and for the most part, it's a fairly minor change. Am I correct from my reading that there's a definition of produced water in the Water Quality Act, as well as this definition in this proposed rule?
I would have to check for sure. I don't, off the top of my head, I do not recall if there is a definition of produced water in the Water Quality Act. It seems to me that there may have been such a definition added as a result of the Produce Water Act, but I don't recall off the top of my head. I'd have to go back and look at the statute.
And that's fair enough, because that was not part of your direct testimony. But based on your multiple years of rulemaking background, isn't it correct that under the State Rules Act, it specifically indicates a word or phrase that is defined in an applicable statute should not be defined in the rule? Meaning, if there's a definition in the Water Quality Act, we do not repeat it in a subsequent rule. Is that your understanding of the State Rules Act? And I can give you a specific citation if that makes Council Fox more comfortable. 14-4-5.7B under the State Rules Act.
Okay, Commissioner Dominguez, Mr. Chair, members of the commission, I do seem to recall that provision being in there, so I'll take your word for it.
Okay.
I think that would be grounds for deleting another definition here. But on the other hand, I personally see some value in having terms that are defined in the statute repeated in the regulations, because then you have all of the definitions there in one place. So I would not recommend following that particular provision of the regulations, but certainly the commission could do so if you think that that would help to simplify the rule.
Okay, let's firstly go with my assumption that they do mirror each other at the beginning, but then it's expanded on in the rule itself. So you have two terms then, one defined in statute, one defined in rule. And the State Rules Act then goes on to indicate a conflict between a definition that appears in a rule and in an applicable statute is resolved in favor of the statute. So even if the commission was trying to make it more clear in the rule to help with administration of the rule, the statutory definition overrides that. So can the commission even go down that path?
Commissioner Dominguez, Mr. Chairman, members of the commission, as long as the definition in the regulations that the commission would adopt is either identical to the statutory definition or entirely consistent with the statutory definition, then yes, the commission can go down that path. I've certainly seen examples where the definition in the regulations will be more specific, will include more terms than the definition that's in the statute. The two definitions have to be consistent, but the regulatory definition can be more detailed.
Okay, thank you, Mr. DeSalen. I believe that's all the questions I have, Madam Hearing Officer.
Thank you, Commissioner Dominguez. Commissioner McWilliams?
I have no questions.
Okay. Vice Chair Armstrong? Okay. Commissioner Fry?
No questions.
All right. And if you would introduce yourself.
Good morning. I came up here prematurely. I'm Carrie Olson representing Namoga, and I believe I'm first in cross-examination.
I think you are. So I think if there are no more commission questions, we can go to you, and you're in a good place to conduct cross.
Okay, great. Good morning, Mr. DeSalen. Getting used to the microphone again.
Good morning, Ms. Olson.
Carrie Olson on behalf of Namoga. I just have a few questions for you this morning to the beginning of my outline. So I just want to start with the background in your testimony and the background that you gave this morning. You summarized extensive experience working on drafting regulations. And I think you started with your time at the EPA, is that correct?
That's correct.
And then I think some of the recent examples you listed, you stated that you participated in the triennial review before the WQCC.
That's correct.
And that was on behalf of an interested party, not on behalf of the commission. Is that correct?
That's correct.
And the same is true of your participation in the Clean Cars Rule. You weren't acting on behalf of the Albuquerque-Bernalillo County Air Board. It was on behalf of an interested third party.
Yes, I was representing a nonprofit organization and a number of nonprofit organizations, but no, in those rulemaking proceedings, I was not representing the board or commission that were adopting the rules.
And I apologize if you said this already, but you've reviewed the department's rebuttal exhibit 175 with their additional proposed red lines to the rule, which I'll refer to as the new Part 8 that's pending in this rulemaking.
Yes, I have reviewed it. I don't remember it all. I haven't memorized it all, but I have reviewed it.
And have you also reviewed Ms. Fulham, the department witness's rebuttal testimony addressing some of the changes that the department proposed in that exhibit? And I believe that's NMED Exhibit 176.
Yes, I have reviewed that.
Do you support the department's proposed revisions to 20.6.8.2, which is the scope section, to clarify the new Part 8 is intended to apply only to permits and discharges regulated by NMED?
I don't believe we have taken a position on that particular proposal.
Okay, so your testimony for clarification is you're not taking a position.
I think that's correct. Our counsel may revise that in the post-hearing briefing, but at least right now, as far as I'm aware, we have not taken a position on that.
And is it your understanding the rule as proposed before the department proposes regulations, the scope applies to all persons subject to the Water Quality Act? We can look at the scope section.
Yes, I would agree with that.
And in your extensive background and experience and work before these agencies, are you aware the Oil Conservation Division is delegated authority by the Commission to administer the Water Quality Act regulations pertaining to disposition of produced water from oil and gas related activities that are subject to the Water Quality Act?
Yes, I think historically that has been the case, but I think that the Produce Water Act has changed those responsibilities somewhat.
Okay, are you aware of something specific where the Water Quality Control Commission has revoked delegation to the Oil Conservation Division?
No, I am not.
Objection outside the scope. I've sort of let this go for a few questions, but this entire line of questioning has been outside the scope.
Yeah, Ms. Olson?
Well, I believe Mr. DeSalen's been presented as an expert on the drafted rule and providing information. So if I can't ask him about the drafted rule, I'm not clear what his role is here.
Okay, so repeat your last question.
Well, he already answered it. Do we need to go through it
Okay.
again?
No. All right, sorry, then what's your next question?
Okay. And so if we go to the objective of this Part 8, will you agree with me that an objective of the Part 8 is to supplement the Commission's existing Part 2, 20.6.2?
Say that again?
Do you agree that the objective of the rule Part 8 is to supplement the Commission's existing 20.6.2?
Yes, I think so.
And this goes to the definitions, which I believe you've testified to. The Oil Conservation Division is designated by WQCC as a constituent agency. Is that your understanding?
Yes, that's correct.
And the OCD would therefore fall into the definition of department under 26.2, but it does not fall into the definition of department under the new proposed Part 8. Is that your understanding?
That is not an issue that I addressed in my testimony. So I mean, I would have to look at that and see how the definitions fit together, how the different regulations fit together. So off the top of my head, I don't think I can answer that.
Okay, in your knowledge and experience in legislative drafting and working on regulations, would you agree with me that if those definitions are inconsistent, that could be a source of confusion if it's not addressed in this rulemaking?
Objection vague.
Right, it does sound vague. And I think you're inviting speculation unless you have an example of inconsistency in the record.
Well, that is the example, the definition of department, and I thought Mr. DeSalen was here as an expert.
Sure, he's here in connection with the testimony that he gave, but I think you're asking him to speculate on something that he didn't testify about.
Well, I believe he is here today testifying to problems with the definition section, and I'm asking him about a problem with the definition section and asking if in his knowledge and experience that could be a source of confusion. I think he can answer, I don't know, if he doesn't know.
Okay, but you haven't pointed to, or at least I didn't hear it, definitions that are inconsistent between 20.6.2 and 20.6.8.
I can repeat the question. My question is about the definition of department.
Oh, okay. Okay.
I can repeat the question. Do you agree that if 20.6.8 is defining department one way and 20.6.2 is defining department another way, that that could be a source of confusion if it's not addressed in this rulemaking?
Again, I would have to look at the structure of the two different rules, which I have not done for purposes of my testimony today, and see how the two rules fit together. There are certainly examples of different bodies of regulations that define the same term differently. Sometimes that's totally appropriate. There are other times when it can create problems. I don't know about this particular set of rules.
Understood. And going back to your testimony earlier was that you do understand this Part 8 supplements the existing Part 2. So going back to that, is it your general understanding that the definitions in 20.6.2.7 would apply unless they're specifically modified by the proposed Part 8?
I think that's right. But again, I'd have to think some more about how these rules fit together. And again, I haven't done that for purposes of my testimony today.
Okay, are you aware that a number of the definitions in 20.6.8 merely cite to a corresponding definition in 20.6.2?
Yes, I am.
Do you agree it could create confusion if Part A does that with some, but not all definitions from 20.6.2?
I don't know that it would create confusion, but I definitely think there is some merit to doing that type of cross definition consistently.
And switching gears a little bit, were you here for the department's opening statements and testimony?
I was here for the department's opening statement and some of the department's testimony, but not all of it.
And it's been a few months, so it's probably a little rusty on all of us.
I'm afraid so, yes.
Do you recall hearing the department's the part of the opening statement explaining this rule is intended to set up a framework to guide future rules?
Yes, I do remember hearing that statement during the opening statement.
And do you understand that to mean that this would be potentially a first step in a multi-step process going forward?
Potentially, but not necessarily.
Would you agree with me that it may be difficult for stakeholders to understand or evaluate the real impact of the rule from only the framework that has been provided without seeing how the definitions would potentially be used in the future?
Objection outside the scope.
Yeah, I'm not sure I was able to follow that actually.
Well, I understand Mr. DeSeelan to be raising concern about definitions that are used in the rule that aren't found in the rule that could potentially be used in a future permit. So I'm not quite clear why Ms. Fox is saying that my question about the future rule is outside the scope.
Right. So he did testify that to the extent terms needed to be defined in the future, they could be defined, I think, in the future. So if you would please repeat your question.
Okay. Do you think it's difficult for stakeholders to understand or evaluate the impact of this rule from only the framework that has been provided?
As to some of the things that, some of the definitions, for example, that we recommended be removed, yes, I think that definitely can cause confusion to stakeholders, and that is why we recommended that they be removed. But there are other provisions in this rule that we think are very important and don't create any confusion and can be adopted now.
So you agree it would be difficult for the stakeholders or the commission to understand whether or evaluate whether a proposed definition is accurate without knowing how the term will be used in the future?
To the extent that it's a definition that is not used in the body of the rule, yes, that's my testimony.
I'm just skipping over a few of the things that have already been asked. So I believe Commissioner Dominguez asked you about definitions used in the Produced Water Act, or maybe just in the Water Quality Act. Specifically, he asked you about the term produced water. You responded that you weren't aware whether the term produced water was defined in the Water Quality Act. Was that accurate?
I don't think I used the word I wasn't aware. I just wasn't sure. I know I have looked at these provisions before, and several months ago, I might have had it at the top of my head that yes, there's a new definition of produced water that was added by the Produced Water Act and included in the Water Quality Act. At this point, I'd have to go back and look to refresh my memory to recall if that is the case. So I take an issue with the word aware. I don't recall at this point.
Okay, so that's with the Water Quality Act and the Produced Water Act. You don't know sitting here today whether produced water is defined in either of those acts?
I don't recall.
Sure.
I think that it is, but I don't recall for sure.
Okay. So I think the scope of Commissioner Dominguez first asked you about repeating a statutory definition, but he also asked you about consistency with definitions. And just for clarification of the record, you agree the Water Quality Control Commission doesn't have authority to define a term in a way that is inconsistent with the statutory definition in either the Water Quality Act or the Produced Water Act?
If I understand your question correctly, Ms. Olson, yes, I agreed that a definition in the regulation should not be inconsistent with the definition in the statute.
And do you agree that some of the drafting concerns you raise in your rebuttal and direct testimony
could create problems for implementation of the rule down the line?
I think the problems are that it creates confusion. Whether it would create problems, I'm not sure. I don't think that was my testimony.
So in your knowledge and experience, do you agree there's a concern with implementation if the drafting concerns are not addressed?
If there are legitimate drafting concerns with the proposed rule and those concerns are not addressed, then yes, it can create problems in the future, certainly.
And is it your testimony that the concerns you've raised are legitimate drafting concerns?
Yes, they are. Whether every one of the issues that we raised are things that could create significant problems in the future, I'd have to go back and look through them. They certainly will create confusion and potential problems, but I don't know if I would agree with your statement as to every one of the regulatory changes that we have proposed.
Okay, that's all the questions I have. Thank you.
Okay, thank you, Ms. Olson. I neglected to check with the commissioners on the platform to see if they had questions. I believe Commissioner Rosatos. Do you have a question of Mr. DeSalen?
Thank you, Madam Examiner. No, I do not have any questions. I appreciate it.
All right, thank you. Are there other commissioners on the platform? Okay, thank you, Pam. In that case, let's go to Mr. Maxwell. Mr. Maxwell, do you have questions of Mr. DeSalen?
Your Honor, commission members have probed into my questions. I have no questions today. Thank you, Mr.
All
DeSalen,
right.
for being here.
Thank you. Ms. Taylor? Mr. Cox?
No questions.
Thank you. Mr. Hightower? Okay. Mr. Davis? All right. Ms. Nanasi or Mr. Dodd? All right.
Good morning, Mr. DeSalen. My name is Chris Dodd. I represent New Energy Economy.
Good morning, Mr. Dodd.
First, I want to talk to you about the excess use of definitions in the proposed rule. You agree that there are too many definitions contained in this proposed rule?
It's not so much that there are too many as that there are a number that are unnecessary.
And that they're unnecessary because they're either not used in the rule at all, or they're only used in defining other terms?
That's correct.
For example, I believe you testified on rebuttal that approximately 8 of the definitions are used only in other definitions, which creates a needlessly complex and convoluted structure.
That's correct. I don't think that number was what I most recently testified to, and I don't think it's what's in our chart. But yeah, there was some confusion about the numbers.
Yeah, and I'm not going to quibble with you over the number of definitions.
I can see that.
Great. So basically, your testimony is that you should only use the definitions that are actually needed to make the rule clear. Correct?
I would agree with that, yes.
Basically, keep it simple so that it's easily understandable.
Correct.
Now, I want to walk through a hypothetical, okay?
Okay.
Let's imagine that we're writing a rule dealing with cats and dogs on public sidewalks. Okay.
Okay.
In the initial draft of this rule, we have a definition section that includes 3 definitions.
That includes what?
3 definitions.
Okay.
First, cat means the domesticated mammal of the species Felis catus. Okay.
Okay.
Second, dog means the domesticated mammal of the species Canis familiaris. Okay.
Okay.
And third, domestic animals, which means cats and dogs. Right.
Okay.
And then we have the operative language of the regulation, which states, quote, no domestic animals are allowed on public sidewalks, close quote. All right.
Okay.
Now, in this situation, we're using domestic animals to define, or basically to encompass cats and dogs. But you would agree that it would be better to simply cut the definition of domestic animals and simply make the operative language of the regulation state, quote, no cats or dogs are allowed on public sidewalks, right?
I think that's right. Yes.
Because it's more clear, correct? It removes complexity and convoluted structure.
Correct.
And it also helps remove a definition for domestic animals, which by common sense might include more than just cats and dogs, right?
Correct.
So with this hypothetical in mind, I want to talk about the definitions for bench scale project, pilot project, and demonstration project, which are contained in both Amigos Bravos / Sierra Club's proposed rule and NMED's proposed rule. Okay.
Okay.
Under both proposed rules, a bench scale project is, quote, a project or study conducted in a laboratory, close quote, right?
Okay.
Do you agree with that?
Well, I'd have to go back and look.
Please, can you pull up your proposed rule?
I think I can do that. Is this it here?
Thank you, Ms. Fox.
Might be quicker than scrolling through my computer. So we're looking at a definition of
First is the definition of bench scale project.
bench scale project.
And the question was, let me know when you see it.
Okay, I'm there.
So a bench scale project is, quote, a project or study conducted in a laboratory, close quote, correct?
That's correct.
And then if you could flip to the definition for pilot project, please.
Okay, I'm there.
A pilot project is, quote, a representative engineering scale model or prototype system that is beyond the bench scale and tested in a non-laboratory environment. A pilot project represents an increase in the technological scale than otherwise achievable in a laboratory and often involves larger quantities of materials over longer periods of time, close quote. Did I read that correctly?
You did.
And then we get to the definition for demonstration project. You could please go to that definition.
Okay.
A demonstration project is a bench scale or pilot project as defined in the rule, correct?
That's what it says.
And just to be clear, those 3 definitions are the same in Amigos Bravos and Sierra Club's proposed rule and the proposed rule of NMED, correct?
I believe so, yes.
Now, if you look at the operative portion of the rule, I want to direct you to part 400. Is it correct that the terms bench scale project and pilot project are not used?
Based on a very quick review of the regulation, I think that's correct. Those terms are not used in Part 400.
Instead, the term that's used is demonstration project, correct?
Correct.
Wouldn't you agree that just like in my cats and dogs regulation example, that it would be clearer, better drafting to get rid of this term demonstration project and simply use the terms bench scale project and pilot project throughout the entire rule?
Off the top of my head, I would agree with you, but this is not an issue that I testified about. This is not a proposal that we made. And I would really have to think about it some more and look at the rule and the structure of the rule some more before I could give you a definitive answer to your question.
Okay. If pilot project, the term pilot project and the term bench scale project are not used anywhere else in the rule and are only contained within the definition for demonstration project, if that's correct, would you agree that we ought to just get rid of the concept of demonstration project, get rid of that definition, and just use the actual terms that we intend to be covered in the rule?
Yes, it seems to me that that would be a simpler way to approach it. But again, I didn't look at this rule carefully with that issue in mind. So I don't feel comfortable giving you an absolutely definitive answer, but I think I agree with what your point is.
Thank you. Now I want to talk to you about the permitting process contemplated by both Amigos Bravos and Sierra Club's proposed rule and the proposed rule of NMED. Okay.
Okay.
Neither NMED's proposed rule nor Amigos Bravos / Sierra Club's proposed rule requires that a person obtain a permit prior to using produced water for pilot projects and bench scale projects, correct?
I think that's correct.
Instead, both proposed rules contemplate a notice of intent and determination of, quote, no discharge permit required, close quote, prior to the project being conducted, right?
That's my understanding.
And so these rules do not require a permit to use produced water off of the oil field, correct?
Under certain circumstances, I think that is correct, yes.
Now, I'd like to read you a few statutory provisions and ask you a couple of questions about them as they apply to these proposed rules, okay?
Okay.
You're familiar with the Produced Water Act, right?
I'm sorry?
You are familiar with the Produced Water Act?
I've read it. I've read it probably a few times, but I've never implemented. I've never become really familiar with it. So yeah, I have a general familiarity with it.
Okay.
But that's all.
So section 70-13-3B, which is a portion of the Produced Water Act, states that, quote, it is the jurisdiction of the Water Quality Control Commission to regulate produced water as provided in the Water Quality Act, right?
Yes, I recall that, and that sort of harkens back to my response to some of the questions of Ms. Olson.
Sure. And section 70-13-4D, another provision of the Produced Water Act, states, quote, for uses regulated by the Water Quality Control Commission pursuant to the Water Quality Act, a person shall obtain a permit from the Department of Environment before using the produced water, the recycled or treated water, or treated product, or any byproduct of the produced water, close quote. Did I read that correctly?
Well, I don't have the statute in front of me. That sounds familiar, but I can't promise you that that's correct.
Okay. Now, and just for the record, I would note that that statute is contained at NMED Exhibit 19, Bates number 000263. Now, that portion that I just read, what that means is that prior to using produced water in any way that is subject to regulation by the Water Quality Control Commission, the person has to get a permit from the NMED, correct?
We are getting into an issue in the statute that we have not, Amigos Bravos and the Sierra Club have not taken a position on, so far as I'm aware. There's a question there, I think, and I think this is what you're getting at, as to whether the Produce Water Act expands the authority of the Water Quality Control Commission beyond what's already in the Water Quality Control Act. And my interpretation of the Produce Water Act is that, yes, it does. But I don't think that there is any definitive interpretation, and I think the statute is probably at least somewhat ambiguous on that point.
Okay. Now, the Water Quality Act, that is Chapter 74, Article 6 of the New Mexico statutes.
That's correct.
And you are aware that the bill that enacted the Produced Water Act also amended the Water Quality Act.
That's correct.
The legislature did two main things to amend the Water Quality Act when it enacted that bill, right?
You could characterize it that way, yes.
The legislature defined produced water in section 74-6-2, which is the definition section of the Water Quality Act, correct?
Okay.
Does that sound familiar to you?
That sounds correct, yes.
And then the legislature also added an additional duty of the Water Quality Control Commission under the Water Quality Act, correct?
That's correct.
And that is subsection P of section 74-6-4, correct?
I don't remember specifically what the subsection letter is, but it would be somewhere around that, yes.
And so in that statute, it says the commission shall, and then it lists lots and lots of
Right.
different requirements under the WQA.
Right.
And subsection P states the commission shall at the top. P, adopt regulations for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition in road construction maintenance, roadway ice or dust control or other construction, or in the application of treated produced water to land, for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas, correct?
That sounds very familiar, yes.
And so wouldn't you agree that if someone wants to discharge, handle, transport, store, recycle, or treat produced water, they need to first obtain a permit?
Madam Hearing Examiner.
Objection outside the scope.
Yeah, Mr. Dodd, I don't remember him addressing this angle.
If I could respond briefly, please. This is an expert who's testifying as to the substance of the rules that are proposed by Amigos Bravos and Sierra Club. I'm asking about a particular section of those proposed rules, and that basically they're in conflict with the law. And that's what I'm trying to demonstrate here. And I think that is within the scope of this expert's testimony.
Okay, go ahead.
And so wouldn't you agree that under the statutes, permits are required prior to any use of produced water off of the oil fields?
I think that is an interpretation of that statutory provision that I would probably tend to agree with.
Wouldn't you agree that bench scale projects and pilot projects involve the use of produced water?
Madam Hearing Examiner.
Yes.
I'm over here.
I'm sorry, this is not Namoga's witness, Madam Hearing Officer.
No, I understand. Ms. Olson.
I'm going to object to this questioning on the substance of the rule. Mr. DeSalen's testimony is onto drafting of the rule. I don't think he testifies to permitting or requirements for obtaining permits. And I also don't see in his testimony where he testifies to interpretation of the statute.
All right, and I accepted Mr. Dodd's representation that he wanted to explore what he believed was an inconsistency between the proposed changes to the rule made by Amigos Bravos and Sierra Club and New Mexico state law. Have we strayed from that?
No, I can actually just go to my next question, which I think will hit exactly on that.
Okay.
Both NMED's proposed rule and Amigos Bravos and Sierra Club's proposed rule do not require permits for the use of produced water in bench scale and pilot projects, do they?
That's correct.
And you would agree that that is inconsistent with the binding statutory authority, correct?
Not necessarily.
Depends on what interpretation you take of those.
That's right.
Those statutes.
That is correct.
But you said you would tend to agree.
I think that's correct. That was my testimony.
Okay. And so you would tend to agree that these proposed rules are inconsistent with the statutory provisions.
Well, I think I used the word tend to agree in response to a slightly different question. I think my response to that question is I'm not sure.
Okay. Thank you very much. That's all the questions I have.
Okay.
Madam Chair,
Mr. Commissioner Brankard.
I think there's a really important point here about what's relevant or not. The department makes a proposal. Other parties propose changes. The fact that a party does not make a change to the department's proposal doesn't make it that party's proposal. I think they can only be questioned on their proposed changes, not on other parts of the rule if they didn't propose to change. And that's what I think was going on here.
Okay. All right. Thank you for that. Thank you, Mr. Dodd.
Thank you, Madam Mayor.
Mr. Knight.
Thank you, Madam Hearing Officer, Chair, and Commissioners. I just have a few questions. I think most of my questions were addressed by Commissioners Brankard and Dominguez, but I'll just gonna that clean up here. Mr. DeSalen, good morning.
Morning, Mr. Knight.
You stated previously that you understand that this is a supplemental rule. Is that right?
I don't think I said it was a supplemental rule. I think I agree that it supplements pre-existing rule. I guess that means the same thing, but I just want to make that clear.
Fair enough. You understand that.
Bless you.
The department believes it has the need for these definitions for implementation in existing reuse permits, given that this is a supplemental rule for the already codified permitting regulations in 20.6.2. Is that correct?
Yes, I heard the Environment Department witnesses testify that they felt that these rules were necessary for implementation of the current permitting program. I think I disagreed with that conclusion in my testimony.
And do you understand that the department's intent with this rule is to create a framework within which all future reuse rules can be located?
Yes, I heard the Environment Department witnesses say that that was their intent. I disagree with the merits of creating a framework that includes definitions that aren't being used in the body of the rule. So yeah, that was the Environment Department's intent, but I don't agree with how they're going about it.
And you understand that this rule pertains to reuse of water from all sources. Is that correct?
By all sources, you mean produce water, industrial wastewater, and domestic wastewater?
Yes.
Yes, the rule in some ways addresses all of those sources of wastewater.
And are you aware that there are definitions for unused terms in other regulations that the department implements?
Sure. I mean, I wasn't there when those regulations were adopted. I didn't have the opportunity to review them and comment on them, or I would have given very much the same comments that I gave here. But yeah, sure. There are lots of mistakes. There are lots of problems in the New Mexico Administrative Code, especially if you look through the whole thing.
And let's see, are you aware that 1.24 NMAC, the rulemaking rule, as we'll call it, identifies the Administrative Law Division of State Records Center and Archives as the delegated entity for determining if a regulation meets style and formatting requirements?
I think that's correct.
And do you recall testimony that was given by the department at the beginning of this hearing that the Administrative Law Division reviewed this rule and did not have any suggested edits in regard to the inclusion of the definitions that you're opposing?
Yes, I heard that testimony, but I don't believe that the Records Center looks for those kind of issues when it reviews a rule.
And would you agree that the commission has the authority to adopt definitions that aid in implementation, even if those terms do not appear in the text of the rule, but that you don't think they should do that in this instance? Is that accurate?
Yeah, I think that the the Water Quality Control Commission has the authority to adopt definitions that aren't used in the rule.
Okay, thank you. That's all the questions.
Thank you very much, Mr. Knight. Anything? Oh, first, let me go to Ms. Fox. Do you have follow-up?
Just one question, Madam Hearing Officer. Mr. DeSalen, today as you sit here, you're not offering an opinion whether the Produced Water Act and the Water Quality Control Act require the department to issue a permit for industrial use or industrial projects or demonstration projects that do not discharge to groundwater or surface water, correct?
I think that's right.
That's all.
Okay, thank you. There's nothing further, and we can excuse, Commissioner Brankard.
Yeah, sorry, I just wanted to follow up on an interesting point made by Mr. Cox about the demonstration project definition. Would another alternative for the commission's consideration be to take the definitions of, bench scale project and pilot project, put those words into the definition of demonstration project, and then eliminate bench scale project and pilot project?
Yes, I think that would make sense. But again, Commissioner Brankard, Mr. Chairman, members of the commission, I haven't looked at it real carefully or closely to analyze how that would work. But
as you described it, Commissioner Brankard, I think that would work and it would make sense.
Thank you.
If there's nothing else from the commission, we can excuse Mr. DeSalen. Thank you very much for your testimony, Mr. DeSalen.
Thank you, Madam Hearing Officer, Mr. Chairman, members of the commission.
Right. So I understand, Ms. Fox, we've heard from both of your witnesses. All right. So Ms. Nanasi, NEE would go next, and I understand if you would please just address the order in which we'll hear from your witnesses and the time constraints that I understand some of your witnesses have. There's a handheld mic on the corner there.
Hello. Hello. We are prepared to do opening and start with our first witness, Mr. Gom, and continue throughout the day. And then I believe that I talked to you and the other parties that Mr. Noble is flying in tonight and will be prepared to present his direct and then sit for a cross-examination. So if we're not done with Mr. Gom, I would ask your indulgence because he's flying in to deal with Mr. Noble on Tuesday. If we finish early on Tuesday with Mr. Noble and Mr. Gom has not concluded, then he should go continue on. And then Dr. Van Gogh is prepared to start Wednesday morning after public comment at 10 a.m.
All right.
And Mr. Dodd is going to do opening, and then I will put on the three witnesses.
Thank you.
Thank you.
Mr. Dodd, why don't you go ahead with opening, and we are going to take a break by noon because we're returning for a 1 p.m. public comment. But let's see if we can't at least get the opening
I
done.
should be able to get over.
All right.
Yeah, just one moment to grab some.
Okay.
Mr. Chairman, members of the commission, Madam Hearing Officer. I'd like to begin my opening by discussing one of the concerns raised by Commissioner Brankard in his questioning of NMED's witnesses. The breadth of the WQCC's authority and duty to regulate produced water. Your duty and authority is clear and expansive. It is your authority and duty to regulate produced water in New Mexico off of the oil field. Off of the oil field. What is the scope of that duty and authority? As former New Mexico Supreme Court Chief Justice Charlie Daniels would always command, read the statute. And so let's turn to section 74-6-4P. It states that the commission shall adopt regulations to be administered by the Department of the Environment for the discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition in road maintenance and road construction maintenance, roadway ice or dust control, or other construction, or in the application of treated produced water for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas. This says that you shall adopt regulations, but it does not say what those regulations have to be. They can be prohibition. And New Energy Economy is here to tell you that the science, as you've heard from NMED, does not support any use of produced water off the oil field. Even the science that Namoga has put forward, which we'll hear about more, Exhibit 139, which was published in April of 2024, tells simply to do more science, that no uses have been determined to be protective of health, safety, and the environment. One of the things that this commission should consider is the legislative intent behind the Produced Water Act. As former Speaker of the House Brian Egoff, the sponsor of the Produced Water Act, explained in his correspondence to the Oil Conservation Commission, the Produced Water Act stripped the OCD of its authority over the use of produced water outside of oil and gas industries. Speaker Egoff's correspondence is New Energy Economy Exhibit 3, and I have copies for the members of the commission and for the parties. May I approach? Thank you. Speaker Egoff wrote, quote, "This act clearly removed that authority from OCD and established instead that the Water Quality Control Commission and the New Mexico Environment Department shall regulate all aspects of any off-oil field use of produced water. The legislation thereby clearly established that the use of produced water outside of the oil field shall be the responsibility of those public bodies charged with the protection of New Mexico's water quality and environmental security. The Water Quality Control Commission is also instructed specifically by statute to employ sound, credible scientific data and to protect public health and welfare," close quote. NMED is trying to do its job. Energy economy acknowledges that. But NMED has erroneously embraced a narrow, mistaken reading of the applicable statutes, and thus the proposed rule is a reflection of their misunderstanding of the law. The water quality folks at NMED are used to operating within the traditionally constrictive confines of the Water Quality Act, and so it is not surprising that they would read the Produced Water Act provisions and view them through the narrow lens of the WQA and the mistaken belief that they can only require permits for discharges. This is incorrect. Subsection P is a provision of the Water Quality Act, and it requires the Commission to establish comprehensive regulations to control all aspects of off-oil field discharge, handling, transport, storage, recycling, or treatment of produced water. Accordingly, Section 70-13-4D provides, quote, "For uses regulated by the Water Quality Control Commission pursuant to the Water Quality Act, a person shall obtain a permit from the Department of Environment before using the produced water," close quote. That is the law, and it is clear. Any use of produced water outside of the oil fields requires a permit. The current pilot projects are in violation of the law because they do not have permits. By law, this commission's regulation must require permits for any use of produced water or its byproducts. By law, permits are required for any use. The proposed regulation falls short of the statutory command. Exhibit NG21, which is an exhibit to Mr. Gaum's rebuttal testimony, which is New Energy Economy Exhibit 18 complies with the law. And I'd like to hand out copies of that exhibit to the commission. May I approach? We are requesting that the commission adopt our proposed regulation. It is the only regulation that has been proposed that complies with the requirements of the WQA and the Produced Water Act. In his correspondence to OCD, Speaker Egolf further wrote, quote, "I urge you to take care in crafting of these regulations to ensure that none of the rules and regulations adopted pursuant to House Bill 546 inadvertently allow or purport to permit any use, application, or discharge of produced water outside of oil and gas operations. The people of New Mexico will be best served by the adoption of stringent regulations of produced water that put public health and safety first and clearly state that any use of produced water outside of oil and gas operations is prohibited," close quote. Speaker Egolf concludes his correspondence writing back in 2020, quote, "Currently, several universities are conducting research into the reuse of produced water and whether uses of produced water present health and safety risks to the public and our natural resources. The New Mexico Environment Department and the Water Quality Control Commission will be the agencies best equipped to evaluate any such research when it is complete. At this time, I am unaware of any safe, fully researched application for produced water outside of oil and gas operations," close quote. Since 2020, when Speaker Egolf wrote those words, the science has become clear on only one thing. Permian Basin produced water contains radioactive nuclides, forever chemicals, heavy metals, and a litany of carcinogenic compounds, as well as hundreds of unidentified chemical constituents. The research has not demonstrated the safety of reuse of produced water. The science has simply shown us how much more science we have to do before the use of produced water can be contemplated. I have one additional exhibit that I'd like the commission to consider with my opening, and that is New Energy Economy Exhibit 13. This document is New Energy Economy's requests of the commission in a non-technical rule-based format, but more in natural language. May I approach? New Energy Economy requests that the commission adopt a regulation, one, that prohibits the discharge, handling, transport, storage, recycling, or treatment of treated or untreated produced water for any activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas, except as the NMED authorizes by permit. Two, that NMED shall deny certification of any federal permit proposing to discharge, dispose of, or reuse treated or untreated produced water for any activities unrelated to the exploration, drilling, production, treatment, or refinement of oil and gas. 3, that establishes that the only exception to the prohibition on the use of produced water is for bona fide research purposes, and that any person or entity desiring to conduct such research shall, prior to using produced water, submit a produced water research application for permit to NMED. 4, that the application must provide all of the information and satisfy all of the requirements contained within the currently proposed rule, but also that the application must establish that the benefit of conducting the proposed research outweighs the potential risks posed to health, safety, and the environment by the proposed use of produced water in the research. This requires the applicant to explain the value of the proposed research and to identify any risks posed by the use of produced water. By way of illustration, if an applicant were to propose a produced water pilot project on the banks of the Rio Grande, just upstream from the Bosque del Apache National Wildlife Refuge, NMED could look at that and say, you know, we like the research you guys are trying to do, but it's too risky, right? If you have a failure at that project, you're going to demolish this national treasure. And so, no, we're not going to allow it. That's what we're trying to get at here, that you have to weigh the risks and the benefits of the proposed research. 5, that NMED has the discretion to request any additional information needed to determine whether to issue the research permit, right? That way NMED can have all of the information that it needs. And 6, that NMED will only issue that research permit if it determines that the benefit of conducting the proposed research outweighs the potential risks posed to health, safety, and the environment by the proposed use of produced water. This means that if NMED determines that the risk posed by any applicant outweigh the potential benefits, NMED, as the regulator, shall deny the application. You have heard from every single party in this case that there are currently no scientific standards that underlie this rule, and that without scientific standards, the Commission cannot allow the discharge of handling, transport, storage, recycling, or treatment of produced water. Ultimately, New Energy Economy's position is that NMED's narrow, mistaken interpretation of the statutes resulted in a rule that does not meet this Commission's expansive duty to protect the safety, welfare, and environment from the risks posed by produced water. The proposed rule does not comply with the requirements of law, and it must be modified. The law requires permits for any off-oil field use of produced water, and thus the proposed rule is in violation of that requirement. Why did the legislature require a permit? Because no permit means no notice, means no opportunity to be heard. And that's a violation of due process. The persons that could be harmed by the use of produced water have a right to a permitting process where they can be heard and testify about the potential pitfalls of the proposed use of produced water in research. New Energy Economy's position is that the Commission must modify NMED's proposed rule, or it will be nullified by the appellate court. As all environmental groups are, New Energy Economy is concerned about there being sufficient water resources in the future. But this proposed rule is not the answer. The need for good, clean water means we must trust science and protect our existing water supplies from unknown proprietary chemicals that the oil and gas industry refuses to identify. Regulations are risk management, and they require balancing. Regulators must weigh the risk of the enormous irreparable harm posed by the use of produced water outside the oil fields. Not only is there no evidence that produced water can be safely used, the evidence shows that it can't be. Thank you.
Okay, thank you, Mr. Dodd. You have brought us to 11:55. So let's break until 1 when we return. I'm sorry, yes?
I apologize. Can I move in new energy economy exhibits 3 and 13, please?
Okay, are there objections from other parties? 3 and 13.
Your Honor, this is Mr. Maxwell. I object.
What's the nature of your objection?
We haven't heard any expert witness testimony to lay the foundation for these exhibits. I would say we need to wait until then.
All right, so let's take this up later after your witnesses, Mr. Dodd. All right, again, now it's 11:56. We'll return at 1 and accept public comment at that time.